Oh my gosh, Dan, you're back. How was your big trip to the United Kingdom?
Fine.
Okay. I know you traveled all over the UK, saw some family, even got to see a Liverpool football game. That must have been exciting.
Yeah, it was okay.
Really? Just okay? Adam, is it me or does Dan seem, I don't know what the word is, miffed?
Yeah, I'm getting a miffed vibe. I think he's miffed.
Dan, what's up, buddy? What's got you so, miffed?
Okay. I promised I wouldn't get into this, but I'm a bit miffed about the guest host you had while I was away.
Julia Simone Rutgers? I thought she did a great job. She filled in for you. She was funny. She was smart.
And that was the problem. She was perfect. I mean, she's not only a great journalist, she's also a musician and a visual artist and a poet, and she even knows how to ride a bloody horse. And I believe her exact quote was, "I think I'm a way better Lone Ranger than Dan."
Dan, that was just part of a funny bit that we did at the start. I'm sure she didn't really mean that.
Oh, no? When I listened to the podcast, it made me feel, I don't know, dispensable. It's sort of like being in a band and having someone sit in for you on a gig because you're away and the band goes out and gets Mick Jagger.
Oh, come on, man. I mean, Dan, you're still the Lone Ranger to me. People can fill in for you, but nobody can replace you. But given that we had such a great response to the episode with Julia Simone, I do have one piece of advice.
What's that?
I would never go on holiday again. Ever.
The Winnipeg Free Press proudly presents, in partnership with CJNU 93.7 FM, Milgaard and the Lone Ranger. Here are your hosts, Milgaard Sinclair and Dan the Lone Ranger Lett.
And yes, I'm back. I'm back in my seat.
Welcome back.
And,
you are loved. You are loved. You are loved.
I am. And you know what? And Julia Simone, she was great. As a matter of fact, it's actually comforting to know that should either one of us suffer a mishap on the way to the studio or have to leave the country, as we both do, that we have tons of bench strength at the Free Press, although I do want to set the record straight.
Oh dear. He's been talking to me all week about this.
Yeah.
Here we go.
Okay, so, Julia Simone, who's originally from Calgary, and she played up her cred.
Her Calgary cred.
Her Calgary cred, which is totally authentic. Familiar with horses, familiar with the Calgary Stampede. I worked for 5 months for the Calgary Herald, covered the Stampede, okay, in all of its glory, and I do know my way around a horse. I can ride a horse. So I just want to get that out of the way.
I'm so glad that the record has been corrected.
And of this we shall never speak of again.
I'm so glad.
Yeah.
I want to test this horse theory one day.
Sure.
We're gonna test you to see if you can find your way around a barn.
Yeah. Well, I know enough to know not to spend a lot of time around the back end of a horse for a variety of different reasons.
I don't know much about horses, but I did deliver lambs one summer. And that's about as farmy as I get.
Okay, so I know enough about horses to know that's not the same thing at all.
No,
but
it
anyways,
isn't the same thing at all.
No.
But I'm glad that you're back.
Thanks.
And you're back smack dab in the middle of Manitoba politics here, as we see the latest Angus Reid poll has just come out for premier approvals, and I think the Conservatives here in Manitoba expected a bump, as most governments do when there's a budget, especially a pre-election budget that's very friendly and full of a bunch of things that they're hoping to get support on, and didn't quite happen that way.
No. So the timing of the poll might be a little too tight to say that this is 100% captures the impact of the budget, but they started 2 days last week, 2 days before the budget was delivered in Manitoba, and then went for a week. So they would have gone till Monday of this week. So they did capture all of last week and last weekend. And her approval rating fell 1 point to 25%. More importantly, 65% of those Manitobans polled disapprove of her performance, which is probably more a concern than the support number. Because, when it gets right down to it, like every leader of every party, only if you have a third of the people in the province that like the job you're doing, those are your core supporters. It's not actually a bad number, but where if that's all you've got, then you're in trouble. Because, no party can win an election, a majority mandate in an election in Manitoba, without drawing some non-traditional voters over, and that just doesn't seem to be happening.
And not in a two-party system, which generally is Manitoba. Not to downplay the Liberals, of course, and it's just more like having only 25% of support in the province in a two-party system means the other party got a lot of support.
Yeah, it's, and particularly in Winnipeg, and this is going to make a nice dovetail to the other issue that we want to discuss today, which is, the way the Manitoba government, the progressive conservative government, has sort of boxed itself into a corner on the issue of supervised consumption sites for those people suffering from addictions. The spread between NDP support and Tory support in Winnipeg is so profound. Like it's edging towards a 30-point spread, which is unprecedented. So you see in the budget efforts that the government has made to reintroduce themselves, reframe the relationship with people in Winnipeg, tons of tax cuts, tons of spending.
Really overwhelming. It's quite surprising amount of tax cuts.
Yeah.
Even in a pre-budget conservative government, I guess I shouldn't be surprised when I see such tax cuts and checks sent out to people throughout the province. It just seems like such a move after getting the healthcare dollars and making the argument to the feds that we're in dire need of money. Suddenly tax cuts come in and money's being mailed out to Manitobans.
Yeah, I think the worst part about the budget, and this is the Tories, this will go down as the air quotes, historic, which was the word that Premier Stephenson and Finance Minister Cliff Cullen said a gazillion times. That's a rough estimate, gazillion. It could have been more or less, but it was every sentence was peppered with historic. And the problem is that it's a completely in general it's a fallacious way to frame. Because if you spend $1 more than you spent the year before, you can call that a historic investment in XYZ service. The fact is that, whatever they're spending is really, I'm not sure, and this is the problem, I'm not sure anybody can spend enough money now to make up for all the damage that was done when they were spending, they were, funding increases were well below the inflation and the impact of population growth. So I don't think they really, I don't think they bought any love in this poll.
And I think that probably what's happened is the bad stories, as we've seen the stories that have come out, especially around the supervised consumption sites, and the disastrous way that these, I think generally Manitobans have been seen, tax cuts should be seen as highly, something people like, highly enjoyed by Manitobans, but generally has been negatively responded to. But time will tell. But there's some really good things in this budget. There's money for payroll tax exemption. There's the Community Economic Development Board. There's even a partnership with the Assembly of Manitoba Chiefs for lending options. There's some really good things in this budget, things that have been a long time needed and coming, but yet you haven't heard almost anything about that.
No, and it's, speaking of polling, I would love to know what the internal government polling is telling them, because as we also saw last week and into this week, government's starting to respond to things that I would not have expected them to respond to. So we mentioned the issue of safe consumption sites for people suffering from addictions. And so this has been, for years and years and years, this has been the treatment option, the harm reduction option too far for this government. They don't believe in providing a safe and clean place for people to use drugs, even though we're suffering through an overdose epidemic. I mean, literally every day that goes by that we don't have a safe consumption option for people suffering from addictions, another person will die. Every single day, at least. It's actually closer to 1.6 people dying every day. And, so the Tories and their core supporters, they don't believe in this. They don't think it's an option. And so for the most part, they've kind of ignored the issue. We've tried to get government data on overdoses. They hid the data. And then all of a sudden this week that we're recording this, something strange happened. They blinked on the issue. And so the first thing is the government submitted an op-ed, a commentary written by the Minister of Mental Health, and she so this was, her longer form argument about why, the government doesn't support supervised consumption. And, in it, it's like, it's amazing. Like it's like she talks about, while this government believes in treatment, we don't believe in enabling people to take drugs.
It was a total tone shift.
But they also introduced a piece of legislation that they claim opens the window to the creation of more safer supervised consumption sites. We only have one in Winnipeg right now. It's operated, it's a mobile one, operated out of a van by an agency called Sunshine House. They're doing courageous work on their own. On their own, they went and got an exemption from the federal government to do this. On their own, they've gone out and got money to support the service because the province won't support it. So they introduce this legislation. They do the op-ed. So apart from the ins and outs of what this may or may not do for people suffering from addictions, they blinked. Like that is a blink. That's a tell that this is suddenly, they see this as an issue that's related to their lack of support in Winnipeg, and I'm kind of astounded.
And I mean, we can only imagine, just a few years ago, Brian Pallister getting that report on safe consumption sites and throwing it on the floor in the legislature.
Yeah.
I mean, now here we are talking about it, but the way that they've administratively set it up is they really don't have to worry about this unless they get reelected.
Yeah, that sound you hear right now is an enormous controversial can being kicked down the road to somewhere in mid-2024 when who knows who may be in government in Manitoba. So, yeah.
I mean, there's the budget did appeal to certain communities. Like one of the things that was the attempt by the government to get support from is the very large urban young population. So there's $65 million going towards post-secondary institutions, and they're capping tuition. I mean, which government are we talking about here?
Yeah, my head's spinning. Yeah, hold me.
And so, the time will tell whether this budget does get support. I mean, the polling data and when it was taken maybe have indicated that only partially there would be people who would have known about the budget during the polling. But I still think that this government is in really a difficult position going forward. We're only, we're a summer away from where people's attention draws away from the news, and people are starting to think more about their summer cottages, and they're thinking about an election. And then, boom, you've only got a short amount of time, September, October, to gain people's attention.
Yeah. I mean, I think we have to leave open the possibility that she may seek a writ of election earlier than October the 3rd, I think it is. I think for the Tories, there may be a feeling that they got the budget out. I mean, man, every day is jam-packed with announcements that come out of the budget. Today, support for seniors, treatment for people suffering from addictions, mental health supports, physician recruitment. I mean, there may be a feeling that it's better to leave these promises hanging in the air than leave it longer when, the heads in the news media like me go out and find out that nothing, that what they promised they're either not doing or it's been ineffectual. I mean, reporters are so horrible.
We'd like to apologize to all reporters for Dan lumping you all in with him.
Yeah. At one level or another, political reporters all seek to be kind of a dickhead, right? Like
This is now turning into like a motto.
Well, we all want to be respected, but if you're disliked, I mean, I suppose that's kind of a good thing. Like I have a friend of mine who works in politics who says journalists should judge their influence, their impact, not on the basis of the friends they make, but on the basis of the enemies that they make. So in that case, I am like the best journalist ever.
I think, well, I'm always shocked by the number of contacts that you have in all parties across the province, which tells me that you're able to walk that line and in the middle at many ways to both keep those relationships, but then also at times just speak the truth.
Yeah, I mean, I don't. You have to be careful. I don't want this exactly to come across like some of my best friends are, but you know what? Like, it's if you do your job properly, and we have so many great journalists at the Free Press, then you have agency with somebody in every party, like someone who will pick up the phone and tell you what's going on, even if, parenthetically, he slips in his disappointment about the Premier continuing to ignore the request to appear on this podcast, close parentheses. But it's a fascinating time in Manitoba politics. I will say this point, that if the progressive conservatives go on to lose this election, it will not be because Heather Stephenson did not try everything. Like
they're throwing everything right now.
I will give her a lot of credit. If she started with more political capital and a clean slate, who knows kind of where we would be right now. I think
the long specter of Brian Pallister, and if you watch the strategy of the NDP and almost every single speech of Wab Kinew, I mean, he evokes Brian Pallister's name as much, if not more so, than Heather Stephenson. Yeah. You actually won't hear Heather Stephenson's name. You'll hear Premier, and then you'll hear Brian Pallister over and over and over again, because it's a winning strategy, I think, generally, that people feel very disfavorable. He left very, very disfavorably. And I think people look at the healthcare system and they see Brian Pallister. They don't see Heather Stephenson.
And among progressive conservatives, Mr. Pallister has achieved full Voldemort status. He is the name. I
don't think he's around to hear or listen to our podcast anyway.
No, although when I'm going to get that global map, like of where people are listening, and I'm going to look for that little dot in Costa Rica. If there's a couple of dots in Costa Rica, then I betcha.
I would be shocked.
Okay, we're going to shift gears a little bit to a topic that's kind of very close to my heart: wrongful convictions. I kind of, as an investigative journalist, I kind of cut my teeth on wrongful convictions. David Milgaard, I worked on that story quite a bit, and then also James Driscoll and others. And recently, the federal government introduced legislation called the Joyce and David Milgaard Act, which seeks to create an independent commission, finally, to review cases of possible wrongful conviction. And after it was introduced about a week and a half ago, I reached out to Office of Federal Justice Minister David Lametti, and he was good enough to agree to join us for a conversation. So we're going to have that conversation, and then we're going to debrief on that interview with Winnipeg lawyer David Asper.
My colleague at the University of Manitoba and the Robson Faculty of Law.
And the man who first approached me back in the late 80s to ask me if I wanted to go to Stony Mountain Penitentiary and meet his client, David Milgaard. And talk
most known about the advocacy on David Milgaard's legal team. Real icon in Manitoba legal circles. And so we're really lucky to be able to debrief a little bit on the interview with David Lametti with David Asper.
Absolutely. And so here we go, off to our interview with the Federal Justice Minister David Lametti. I am lucky today to be joined by David Lametti, who is the Minister of Justice and the Attorney General of Canada, and is also the author, with, I'm sure, many other people in his department, of a new piece of legislation for the creation of an independent commission to review cases of possible wrongful conviction. And Minister Lametti, thank you very much for joining us today.
It's a pleasure to be here, Dan. Thank you.
As we were discussing just briefly before we started the recording, myself in particular and the Winnipeg Free Press have a really deep connection to the stories of wrongful conviction. We were among the first news organizations to report on the David Milgaard case. We also got quite a bit of attention for the work we did in the James Driscoll case. So I can sort of say with no exaggeration that right off the bat, I'm extremely pleased at first look and excited about the possibility of an independent commission, because it correct me if I'm wrong, this has really been a thing that's decades in the making.
Oh, absolutely. It's I believe that every single, or at least the vast majority of independent ex post facto reviews, commission reviews, and that sort of thing, have recommended a review mechanism that was independent of the Minister of Justice. And so this is long overdue, and I'm pleased to be the one pushing it forward. So I'm sure this was tucked into just about every briefing book that you ever received on potential legislation and policy priorities. But what's the origin story for you? How did you decide to make it a priority? Because it has been, and again, I don't think this is an exaggeration or unfair, it's been an easily punted policy issue. There's a lot of cans that have been kicked down a lot of roads on this one. What's the origin story for you? How did you come to sort of take this on? Well, I think you're bang on. First of all, that it has been a can that's been kicked down the road far too many times, and I actually fought to get this in my mandate letter in 2019, and I fought to get it in my mandate letter in 2021. It wasn't in our party platform, so it's something that has been of great personal interest to me, and I guess it's a bit in my legal DNA. I have. As an undergraduate, I followed. I mean, I obviously, learned about Stephen Truscott in school, but then I followed what happened with David Milgaard and Guy Paul Morin and others. And by the time I got to law school, it was an issue. And Erwin Kotler was the professor who taught me constitutional law. And when I got named a Justice Minister, Erwin took me aside in his usual fashion with his 15 points, and one of them was, David, you've got to get this done. But the other, and probably the most personal point of contact for me, is that I clerked for Peter Corey at the Supreme Court of Canada. Peter wrote the report of the wrongful conviction of Thomas Sofino, and he recommended an independent commission to review these kinds of potential miscarriages of justice. And I remember I'd long since stopped clerking for him, but we stayed in touch, and he did the report. And I remember he handed me the report personally. He said, David, this is important. And so I take all of that baggage with me as a former professor and again, a student and colleague of Erwin Kotler, but most of all a mentee of Peter Corey, and this had to be done. It's long overdue. When I became minister, there was a case sitting on my desk, and I got to it, I think, expeditiously, and I've tried to do it expeditiously in the 5 cases that have come before me in the last 4.5 years. But 2 things you've got to note as Justice Minister. First of all, I look at the files and say, wow, how did it take so long to get to my desk? And secondly, why only 5 cases in 4.5 years? Like there have to be so many more examples of this out there. There has to be a better way.
So the law has been, I guess, unofficially, I believe it's unofficially dubbed the Joyce and David Milgaard law. And officially, okay, they're officially. And
well, the bill. In any event, we'll see what the law what happens with the law later. But the bill is definitely the Joyce and David Milgaard bill.
That is an observation I would expect the Attorney General to make in our conversation. So well played. I was fortunate enough to know both of them quite well, and to have grieved their passing. David's, just within the last year. Did they play a direct role, either one of them, before they passed, in informing you or motivating you to introduce this bill?
David definitely did. Obviously, I became minister after Joyce's passing, but certainly regard her as a hero in all of this. As someone who just continually went to bat for her son and refused to take no for an answer, and refused rebutted anybody who felt that he was guilty. And so thankfully for her, David was released. I met David in 2019, shortly after having been named Minister of Justice, with James Lockyer. They came up to my office, and again, how could you not be impressed by someone who, after having spent over 2 decades in prison for something he didn't do, who turned his efforts to helping other people and fixing this problem. And so it was hard not to be I suppose, emotionally convinced by David, very persuasive. And I promised him that day. That I would get this done. And so far, I'm keeping the promise. It has to be done step by step, because we're creating something new. And I'm happy to go into the steps later with the commission that Justices Laforme and Westmore and Traoré did for us. But I promised David, and I cried when he died. Like I still get emotional. I wish he had been here for this, and I'm glad that Susan could join us and with James Lockyer the day that we made the announcement.
Right, Susan being Susan Milgaard, who has done just as much work as anybody in the Milgaard family, really, to keep the fires on this issue burning. Again, over the years and all the writing that I've done on wrongful convictions, it's been quite clear to me that none of your predecessors, and by that I mean justice ministers and attorneys general, have seen the political margin or value in engaging on this topic, because it's a thorny issue when you get into discussions with the provincial attorneys general. They ultimately are the authors of the wrongful prosecutions, if that happens to be the issue. They're responsible for policing in their jurisdictions and the role the police play in this. And quite frankly, I think human nature being what it is, they don't like to have these things pointed out. And they take, the provincial attorneys general tend to be very adversarial. What discussions have you had with the provinces about this? And do they remain concerned to perhaps adversarial about what you're trying to do?
No, I'm not. I don't think so. And maybe it's because this has taken so much time, and maybe it's because we've seen so many cases and we continue to see cases. It's just, and I've tried to not certainly cast blame anywhere. Mistakes happen. Whether it's a police investigation that works to a hypothesis that perhaps actually ended up framing the investigation in a way that it shouldn't have, or whether it's a coroner's report that did the same thing, or whether it was a Crown, or whether it was a mistake on the bench or something like that. It doesn't matter. It really doesn't matter how we got there. And I've tried not to cast blame. The advantage, I guess, of the political with a small p advantage of the Laforme Traoré Westmoreland Traoré report was that everybody could read it. And so we did, after we got that report, we did go back to provinces and territories. We did get submissions from police associations, judges associations as well, to get their views on it. And so the report helped us in that dialogue with them to come up with, I think, with a bill that I think has, to be honest, broad support. And so I'm not sensing resistance, and I'm certainly not seeing any any adversarial or outright hostility towards this. I think there's a general view that we've had far too many of these cases in Canadian history. They continue to happen, and we must do something.
So it's I think it's a fair observation that the system that we've had to date, which is the powers of the minister to review convictions after normal avenues of appeal have been exhausted, isn't contained within the criminal code. There is a department within your department, the convictions review group, that does a lot of the spade work, but that the culture around the issue of wrongful convictions has been perhaps the biggest problem. And again, I'll put some blame on the provinces for this. Essentially, it has been, by tradition, the provincial prosecution services have become an adversarial party to the wrongful conviction. They, in many ways, trying to try or retry the cases. And I've personally written about recent cases involving people like Devon Ross, where that it took more than a decade to work through your office, and one of the big reasons was the constant opposition and obstruction, not maybe in a legal sense, but in a more of a metaphorical sense, of the provincial prosecution services. Do you believe that, along with the commission, we need a culture reboot on this? Something that maybe where we can convince the provinces to be a little more interested in a fair and objective review of the cases, and a little less automatically hackles up defending the original conviction?
Well, that's a delicate question, obviously, and I would like, obviously, to bring everybody with us on this, including the provinces and territories, including police and crowns and judges associations. And again, my goal here, not to cast aspersions, but you're right to say it takes too much time. You're absolutely right to say it takes too much time. Part of it is, I think, just the fact that, and the criminal cases review group in my ministry, I know they work hard, and I know they take all this seriously, but they have other jobs too. And so one of the things that an independent commission will do is just have more resources, and this will be the primary and really only focus of that body, and that's critically important. I think that will greatly enhance the speed at which this might move through the system, and that will help people. But they'll also be able to move proactively and move in communities to make sure that people are aware. And we can jump more into this if you want, to make sure that people are aware that this possibility exists. But honestly, I haven't seen prosecutors do their job, Crown prosecutors do their job, defense lawyers do their job. I haven't seen bad faith here, but I am definitely going to say that you're right to say this just takes way too much time, and that's certainly one of the things that motivates me.
So the issue of resources, I think that, like I did talk to Susan and David and James Lockyer after you announced the bill. And I certainly think the issue of resources is top of mind for all the people who have fought for those shown to be wrongly convicted. You don't have a budget yet, and there aren't a lot of details on how support can flow and in what form. I know that a lot of people who do work in this area are hoping that it's not. You don't try to run through provincial legal aid schemes, which have been very problematic. So maybe let's talk about how quickly do you think that the bill can be passed? We're in kind of a dynamic political environment right now, and then how quickly can we start to see some details about resources?
Well, first, just on passage, I'm pretty confident we can get this thing through the House of Commons expeditiously, hoping, quite frankly, hoping by June. I've got support from the NDP Pretty sure I have support from the Bloc Québécois. Daniel Turp is someone when he was in the House of Commons with the Bloc Québécois who was in favor of this kind of commission. And I honestly hope I can get the Conservative Party as well to join in, or at least a substantial plurality. Nobody has any interest in wanting to keep innocent people in jail. I mean, that doesn't serve any purpose whatsoever, except to delegitimize the criminal justice system, as well as create unnecessary victims and prolong the agony of victims of crime. So we will. I think we can get this through by June. I think there's good support. In terms of resources, that's my job to get those resources from the Minister of Finance, and I'm doing everything that I can as we speak to try to make sure that happens. And I take the point from Susan and from James and from others, Kent Roach, others, that this absolutely has to be properly resourced, and I'm doing my best to make sure that happens.
So it's likely. Let's assume that this can get through by June, which would be the spring to summer session of the federal legislature, and then there would be a break. So probably at earliest, we wouldn't see details about resources until the budget following the one that we're going to see later this month.
I'm not certain, because in addition to budget processes, there are off-cycle requests and that sort of thing. So can't assume, I guess, that it will be in the current budget, but also can't rule it out, but also can't rule out that there are other possibilities down the road. Getting it up and running will still take some time. There's absolutely no question about that. Hiring processes are what they are, and putting together the architecture of it, and filling in the architecture of it, if you will, and getting. There's also the actual submission, then has to go through Treasury Board, all that stuff. But I'm hoping to be able to press and get this thing done as soon as possible.
So my next question, I will admit, is. It touches on some pretty big sort of issues, but I'm wondering as well, one of the pressure points or concerns about the current system has been around references from your office for reviews by appellate courts, and then the work that the appellate courts do. And I'm just wondering if you think, to a certain extent, the entirety of the justice system, but certainly those who will be working hand in hand with this new commission to review, that we might need to brush up a little bit on the jurisprudence in this area, creating more of a standard reference, like a format for a reference from this commission to an appellate court. It seems that, and as somebody who painstakingly follows all of the references and all of the work by the appellate courts, it seems like we have to reinvent the reference and the context for these reviews, because right now it's an extraordinary event. It may be less extraordinary in the future. Do we need to kind of brush up, maybe? Yeah, do we need to all go back to school a little bit and sort of get a common understanding of how these things should be handled?
Well, I think we will necessarily have to. I think we'll necessarily have to go back to school. First of all, because we're proposing to change the legal standard in this bill from likely miscarriage of justice to potential miscarriage of justice. We have the language may, and then with an additional element of public interest, which is in other jurisdictions that we've seen that have successfully employed models. So in the UK, Australia, New Zealand, and we have a bit of a hybrid standard, but we've lowered that standard. It's something that Justices Laforme and Traoré asked us to do, and we think that was a good thing to do. So to some extent, that puts us all back in school, and in terms of how we look at the way in which this law operates. But it's also true that there will be more cases. There necessarily have to be more cases. That's one of the reasons why we're doing it. And so there will become, I believe, a greater sense of ease or comfort with the fact that this commission will be able to refer cases back, not just to the Court of Appeal, but they could also, they'll have all the current powers that I have, and which I'm giving up. They can also refer it back to a trial court for a new hearing. Which again, in some cases, is an option. I have to admit, when I'm looking at it, I'm trying to look at them in the most effective lens for the person who is claiming the wrongful conviction. So I will choose either route depending on what I feel will be more expeditious, in particular for the person bringing forth the claim. The commission will develop its own rules of thumb, its own standards, and for its referrals, and the courts will hopefully get used to the fact that this independent body with its own mandate and a great deal of credibility that it will begin to develop over time, will be sending cases back, and it will become part of the new normal.
Yeah, and I mean, I think there's a lot of people who do advocacy in this area that'll be very supportive of what you're describing. I mean, to a certain extent right now, and I don't think that this new commission and the new process and the new standards will change that, but there is a note of finality to this process. When it's referred to an appellate court, there is no process for reviewing that decision. And I think that at least in a couple of instances, Innocence Canada would point out that they don't believe everybody's been on the same page, and maybe not even the appellate courts haven't even grasped the fact that this is it. This is the last stage of deliberation. Nobody is going to review this decision. The stakes are very high in this. Even with the improvements you're making, the stakes remain high, don't they?
Oh, absolutely. Particularly for the people who have been wrongfully convicted, sitting in incarceration somewhere. I mean, of course, the stakes are high, but we need to have a better system precisely, so that we can deal with these cases more effectively, more quickly, and more cheaply, in a way that makes them accessible, makes the process accessible. That's another thing we haven't touched on yet. But all the cases that come up in front of me tend to be men convicted of homicide. But if you look at incarceration, the faces of incarceration across Canada, that's not it. There are plenty of women, there are plenty of Indigenous peoples, a majority of Indigenous people, sadly, tragically, or a great plurality, as well as people of color, Black Canadians, other racialized Canadians, and they're being lost here. It's something that Justices Laforme and Westmoreland Traoré pointed out, and they took specific care to include those voices in their deliberations. But it just stands as a matter of logic that if the only cases that get to me represent only one tiny swath of the population, one kind of case, that we're missing something somewhere else, and we need better data. I know that, but we also need a better system that allows for other people to challenge the convictions that have been mistakenly entered, or the processes that have gone awry that have led to those convictions.
It's I think the great hope of the people that recommended this commission is that it would finally in Canada kind of get more, as you say, to capturing the magnitude of the problem. Of course, the magnitude of the problem is also one of the reasons why I think people fear this commission, is because they quite frankly, it's not clear to them yet where the commission will draw its lines. In the United Kingdom, they were initially approached by people with fairly small and mundane legal issues that were no doubt important to them. There's still a lot of parameters that need to be worked out on this commission, and what cases, like, will it give equal time and effort to the cases of people who are no longer incarcerated as those who are still incarcerated? How do we figure out all that?
Well, I think the short answer is we're going to let the commission figure a lot of that out on its own, to work out their own methodologies and their priorities. Certainly the walking orders I would give them, or the marching orders is probably the wrong term, it's too strong, but the walking orders I would give them is that we do want them to look at these other cases. They've had a massive negative impact on the lives of people. It's not a conviction for homicide, but it is a conviction that incarcerates you for 5 or 6 years on something else that has completely disrupted and possibly even destroyed a life, a relationship, a job, all of that. And so that's important too. And we need to be able to look at those. One of the positive examples, as you've pointed out, from the UK, Scotland, is that the commissions have been able to look at these other cases, and they have been able to. The numbers actually go up, particularly at the outset. Then they stabilize later, which is, I suppose, what we would expect here. But those cases are important too. It's not just the major homicide. Obviously, the major homicide cases are always going to be a priority, but it's not simply those cases that we need to review. It's other cases, and again, with technology changing the way it does, it often is the case that there is an exonerating technology that comes into existence 5 or 6 or 7 or 10 years after the conviction, and we need to be able to look at those kinds of changes and apply them as quickly as possible.
So it's just as we sort of wrap up our conversation, it would be correct for me, if I was paying attention, I think I have been paying attention, that your hope is to see the bill become law by the end of the current session, which wraps up sometime in June. And then following that you're hopeful that there could be some work done to provide some resources to get the commission at least up and running and in the planning and development stage shortly after that, if everything were to go, well.
You're correct on all counts.
Okay, well, you can imagine how many times I hear that. Not very often. Minister, I want to thank you and your people for being so responsive and making time to talk about this. It isn't often the biggest story in the country, but it is actually a huge story to those people that have been touched by this, the narratives of wrongful conviction. So we are hopeful as well that you are successful in your mission here.
Well, thank you. I appreciate your work over the years, and the work of other journalists, of Innocence Canada, of all the lawyers and law students and others who have and families who have not forgotten that mistakes can happen. And so let's get this done. I'm going to keep pushing as hard and as long as I can until this gets done. You have my word there, and I hope too that we will come back in hopefully not too long a period of time and do a victory lap.
Well, I'll use this as an opportunity to tell your people that I'm booking an interview for July, just kind of a progress report, and we'll see where we are there. The Honourable David Lametti is the Minister of Justice for Canada and the Attorney General. And thank you for your time.
Thank you, Dan.
We want to welcome to the Milgaard and Lone Ranger podcast my colleague from Robson Hall Faculty of Law at the University of Manitoba, David Asper. Well known throughout Winnipeg. He's been the chair of the Winnipeg Police Board, chair of the Manitoba Police Commission, and lawyer, well-known business person throughout the province, and particularly worked on David Milgaard's legal team that overturned his wrongful conviction. Welcome to the podcast, David.
Thanks. It's great to be here.
I want to start off by talking about your work on wrongful convictions, and particularly your work with we all know that the justice system in Manitoba has not been kind to Indigenous peoples. My father, of course, headed up the Aboriginal Justice Inquiry back in 1988, and the hundreds of recommendations that came out of there, in large part because of the wrongful convictions or the justice system that's pitted against Indigenous peoples. Can you talk a little bit about your experience as a lawyer in Manitoba, and then also your work with wrongful convictions.
I grew up as a young lawyer standing in line behind your father in line in the courtrooms because he was senior to me. So I got to watch him. And he was an incredible mentor before he went to the bench and served as a judge. And I enjoyed, and I got strength from watching the way he would speak truth to power in the courtroom. And I have a lot of respect for your dad. I do want to start. I mean, we're recording this on March 16th, 2023, and news breaks this morning that 2 members of the Edmonton Police Service were shot and killed. And it's just a tremendous reminder of the risk and the importance of law enforcement in our communities and the risk that these people take. It has special meaning, I guess, for me, even in the context of my own lived experience that led into wrongful convictions, because I wasn't practicing criminal law, and I made a career choice to change my career path into criminal law. And the day I started, March 6, 1986, 2 members of the RCMP were gunned down. One was killed, Corporal Rob Thomas, in Powerview, Manitoba. Rob had grown up as a special constable with Peguis First Nation policing, and then graduated into the RCMP. And I think he's buried at Peguis. And so when we talk about wrongful convictions, and I know we'll do that, I think it's important to keep, the big picture in mind, that there are human beings and there's huge risk in the system. And I encountered that literally on my first day of work as a criminal defense lawyer. And I think it's appropriate today when we're recording to acknowledge and send condolences to the families of the Edmonton officers, the slain Edmonton officers, and to honor and respect the memory of Corporal Rob Thomas, one of Manitoba's own, who was killed in the line of duty. And so that was March 6th, 1986. And then what a week. That was my day 1. And my day 3 was to meet Joyce Milgaard and become involved with, what would become one of Canada's most notorious wrongful conviction cases, and led to a new law which actually bears the name of Joyce and David Milgaard. So life is pretty crazy sometimes.
And it's also, I think it would be impossible in Manitoba to not deal with these issues, particularly in relation to the rampant challenges that the justice system has placed over the past, and the issue of race and the issue of funding as well, and we can't forget too that while we do recognize the incredible work that police officers do, there's also a number of issues within the system that involve police officers, lawyers, judges, that oftentimes create these systems in which the wrong people get both accused, get positioned in particular ways, and then maybe can't always defend themselves appropriately, and then end up in jail for long periods of time. And David Milgaard, certainly that falls into that category.
Well, one of the other things that, and one of the lifelong experiences that sticks with me to this day, was that as I grew into my practice in criminal law, I spent a ton of time in circuit courts in rural Manitoba and on reserve. In Barons River, in Pungassi, in Bloodvein, and Little Grand Rapids, and in the Interlake, Hollow Water, and Fisher River, and in all the way west to Wayway. And I saw things in the system that the new proposed legislation, and I participated in the consultation that led to the new legislation, but I saw what we call pleas of convenience, which is the plea bargaining where people who might be innocent of a crime take a plea bargain and plead guilty because it's the lesser of two evils when they're trapped in the system. And I could see this, and I could see the wheel of the pressure of the system happening in real time. And it was very troublesome, and I'm very glad that part of the underlying rationale and part of the information that was provided in the consultation that led to the new legislation allows for this new independent commission to look into those kinds of situations, which not surprisingly mirror the disproportionate representation in the criminal justice system of racialized people, First Nations, Indigenous, people of color, who get trapped in the system and may be sort of forced into situations where they admit to things that they didn't do.
Now, just for people who may not be as familiar with the concept, listeners who may not be as familiar with the concept, the pleas of convenience. So, and David, you'll correct me if I'm wrong, but at the very intake level of the justice system, it's not unusual to find someone accused of relatively mundane crimes. So these wouldn't be the high-profile violent crimes, but could be property crime, break and enter, even assault. What'll happen is the individual will be charged with a whole broad array of things. I mean, there could be like a dozen different charges that the police lay initially, and it's a lever. It tips the scale, because what it does is it forces defense lawyers to plea bargain and pick one charge out of the big array of things, plead to a lesser sentence than they might get if they go to trial, with both Crown and defense realizing that there's no way the justice system has the time to sort all this out. Is that sort of a fair description of how the pleas of convenience work?
Partly. What you've described is what's sometimes known as overcharging.
Yeah.
So somebody breaks a window and they wind up charged with, what they did was actually a fairly minor offense in the criminal code, but they get charged with, for example, break, enter, and theft, which has a potential life sentence and is treated more seriously, and it may result in them, for example, being denied bail. And so now they're in prison and waiting for a trial, and the Crown attorney comes along and says, will you plead to mischief and let's make this thing go away? And if the person didn't do it, they might say, okay, just because that'll get me out of prison and get this over with, okay, let's do that. So that's one scenario. The other scenario is again sort of related, which is when people are in fact charged with very serious crimes like homicides, mm-hmm. and they're facing, for example, second-degree murder charges, and potential life imprisonment if they're convicted, and potentially a long period in pretrial detention. Again, they look at the utilitarian perspective, which is a plea to manslaughter better if that's on the table? And even though manslaughter has a life sentence potentially, it doesn't have a mandatory minimum, and so there's a couple of variations of how pleas of convenience might work. And I've seen it. As I say, I've seen it firsthand. It's a difficult situation for the defense lawyer, because you have to look at the accused and you have to say, okay, if you're pleading guilty, I can't plead guilty on your behalf or speak on your behalf unless you're admitting to all the things that are required to uphold a conviction.
Yeah.
So clients, who are separated from their community, separated from their families, will just look at you and say, "Yeah, I did it."
Yeah.
And then you go ahead.
So you've had the benefit of listening to some of our interview with Minister Lametti, and I was able to bring him, to a place to talk about some of the real systemic and cultural issues in the justice system that lead to wrongful convictions. Two-part question. Number one is, do you accept what appears to be at face value a pretty deep personal commitment to this issue? I mean, it's politically, it's not a winner, right? There's never been a lot of political appetite to engage on the issue of wrongful convictions. Minister Lametti seems to be, he's staking part of his mandate as Justice Minister to this issue. And secondly, is this Is this the right point, an independent commission, to change those systemic and cultural issues, or do we have more work to do beyond that?
I think that Mr. Lametti is a hero. I honestly, you know full well that it's been 30 years since the Milgaard case was resolved, or more. I can't even remember how many years ago it was. And as he said in his interview, there's been multiple commissions of inquiry and no minister. I guess Irwin Cotler got close, but no minister has had the resolve and the wherewithal to actually see this through. And so I give him immense credit for doing that. And he understands this not at a political level. It's clear that he understands it at an intellectual, a cerebral, a policy, and a systemic level. And I think that's what enabled him to be able to do what he felt was the right thing. And just in that vein, there was this, and he refers to the consultation that had occurred about a year before the actual legislation was presented. And I participated in that consultation. And there was interesting discussion about the scope of what an independent commission might seek to do. So in its simplest, most stripped down version, you look at the most serious crimes, homicides, where people are incarcerated and try to deal with those cases. But the consultation went way, way further to try to cover way broader ground, including deeper systemic issues, including the race-based aspects of where the system has had a disproportionately bad impact. And to his credit, he's come up with a proposal that is really the full meal deal. I think it's very ambitious. We saw the experience in the UK when they created their independent commission, that it was initially overwhelmed. And the minister refers to that. He said, I think he referred to the fact that there were only 5 cases that crossed his desk. And everybody in the system knows that there has to be way more than what is actually coming to light. And so I do worry a little bit that there might be a lot of traffic that gets directed toward that commission. But I guess that's a good thing. And if that happens, then I guess it's better to be trying to react to that than continue to keep it suppressed. So as I say, there have been a lot of ministers of justice that all advocates for an independent commission have encountered along the way. And I'm just extremely grateful that this minister finally did it.
There are so many systemic issues. Certainly the way even the existing limited system tends to weed out claimants of Indigenous or non-white racialized groups. They just don't get an opportunity to participate even in the current system. But I also spent quite a bit of time talking to him about the cultural problem in with the provincial Crown prosecution services, who treat these applications as if they are, that it's like a knife fight to the death. They do not become a participant in seeking justice. They become the adversary of the applicant. And, you and I have talked about that a lot over the years. Is an independent commission, do you think that's the right place to start to address those issues?
It's a great question. I can't give a definitive answer on that. I do know, though, that the independent commission is going to have full powers of inquiry, including compellability of witnesses and disclosure of documents. So I think that with those teeth and with the stature of being a national institution and with proper investigative resources, I think it's the end of the line of the political gamesmanship in these kinds of cases. Number one, just because of the powers conferred on the new independent commission. But the second thing that I do hope does start to change the culture is that a lot of reasons why wrongful convictions happen are not intentional. Some of the race issues, for example, come from unconscious bias. And a friend of mine actually is doing some really interesting work on a case, a very famous criminal law case from Ontario, about unconscious bias and the sort of what we call the ossification of facts in a case, where they get ossified like a fossil in the way that a predominantly white court of appeal describes what it sees as the facts, and how the reality might be quite different. And that's, I think, unconscious bias. And hopefully the commission will start to, I guess, depoliticize or undemonize that aspect. There's many other aspects to why wrongful convictions happen that get people on their heels and get defensive. Police don't like to be accused of participating in a wrongful conviction, and yet at the same time, I've never met a police officer who wants to get the wrong person. Mm-hmm. And yet, once they get into tunnel vision, which is a psychological trick sort of that happens, it's extremely hard to break that spell, and it becomes even harder when there's a demonization of them for having gone down that rabbit hole. And so maybe this commission can undemonize that. Maybe when people give false confessions, to the average person, a false confession is unfathomable. About how could you possibly admit to something that you didn't do? And yet we know what happens. Yeah. And quite often, whoever gets the confession becomes demonized. And so I do think that over time the commission can change the culture. And very well what happened in the Milgaard case is we've got into this pitched battle that was completely unnecessary. If the Department of Justice, if there had been some willing partner to uncover, when we first raised the questions about the Milgaard case, in an independent way, if somebody had actually looked into it, none of the demonization and the fight that had to happen would have been necessary. So I maybe I'm naive. I was very naive, thinking that the Department of Justice was going to link arms with us in the Milgaard case and march off to achieve justice. But I do think that this is a new opportunity, and I do hope it changes the culture.
I 100% agree that when people's unconscious bias are pointed out, not just in policing, but I think it happens almost everywhere, that when you point out someone's unconscious bias, they'll double down often versus admitting or recognizing. And this is often where cultural awareness initiatives really fall apart, because just bringing someone's attention to racism doesn't actually deal with racism. And the calls to action oftentimes say we need to be giving more training, but one of the things that the Aboriginal Justice Inquiry did is really fundamental change, like asking for very substantive change within the system itself, that the system, the idea of punitiveness in the justice system, the idea of how do we railroad people through the system, especially with public defenders, oftentimes is the reason for all of this racism within the justice system. And so if there's one thing that you could change or one thing you could employ today, what would it be in the justice system to be able to, whether it be at any level? I mean, I work with judges. I'm on a board that assists Justice Joyce with this Court of King's Bench here in Manitoba. What is one thing that you could see at any level to be able to employ and engage the issue of wrongful conviction?
I was going to give an address to the in David's honor to the National Judicial Institute, which was having a session on wrongful convictions, and unfortunately, I got COVID, and I couldn't even collect my thoughts, so I wasn't able to do it. But what I was going to say to them, and I thought really carefully about this because this is a very big thought, is that, and again, to your point, the system, the construct of the system is adversarial. The whole idea is that the police investigate, the prosecutors prosecute, and they do their job, and the defense lawyers defend, and the judge and the juries do their job, and everybody's got sort of a lane. And when you set it all in motion and you create the tension of the adversarial system, it produces an acceptable democratic result, a legitimate result. And yet we know that, that's not always the case. And it's not always the case even in cases where there's an appropriate conviction. And so the point I was going to try to make was I just was going to wonder out loud whether we should start thinking about a more inquisitorial system. We can talk about more community level justice systems, and we can talk about less formalistic, less sort of colonial systems. And I actually like the idea of community courts, and they're being used, in various places across the country with varying degrees of success. But I think the core of it is, in the Milgaard case, for example, if the judge, when you have a jury trial, the judge really tries to stay out of the questioning and really stay out of the way of the job of the jury. That's probably appropriate. But in the Milgaard case, for example, if the judge had intervened and started asking questions about the physical possibility of the facts that were being laid out, things that we were able to show demonstrably after the conviction and after the appeals were factually not possible, then this whole thing might have been avoided. And so I think that the change that I would like to see is a more inquisitorial and active role for judges in preserving and overseeing the integrity of the criminal justice process in real time, and not solely relying on what happens in a trial and then the appeal mechanisms, and then eventually potentially an application to a minister of justice. Let's try to deal with these things as they're happening to avoid people unnecessarily spending time in jail.
It's I knew we were going to reach a point where we had to wrap up the interview, and I was going to be incredibly frustrated because we haven't really had a chance to tell all the glorious stories that you and I share from the Milgaard years. Although I do want to say I still remember the video that you guys shot where you walked the route that the police in Saskatoon said the murderer had traveled, and showed that the timing that they had used at trial wasn't possible. So, and I just remember, of all the stuff you gave me initially on our first meeting, that is, sometimes the truth of these cases is very simple to see, but very, very hard to accept.
It's Dan, it's interesting because David, and by the way, it's a podcast. Can't you just go on forever? We could. But the audience numbers drop off significantly right about now. So, I'll sing if you want, or keep trying to.
No, I tried that; it didn't work. So,
what I was going to say was that almost from the very beginning, David kept I was looking at the transcripts and digesting all the facts. He kept saying, "They can't put me in that picture. They can't put me in that picture," and I did not understand exactly what he meant until his sisters, Susan and Maureen, and then Joyce translated and said, "Go walk it." So I took my little camcorder at the time, and as you say, the picture painted at trial was as though it was a static snapshot of a series of facts, and it did not account for the fact that people were in motion. The victim was going in motion from her house to a bus stop. Other witnesses were going from east to west. People were moving. And when you set it all in motion, the victim was at her destination before Milgaard and his friends, allegedly, because who knows whether they were even in the area, were where the Crown said they were, which gave him the opportunity to commit the crime. Yeah. And and what I like about the new commission is that it might be that you can do something like that and go to the new commission, and say, we don't know and don't have access to all the stuff that underlies this, but here's a set of facts that don't work. And again, it's really important. There's an important nuance, and James Lockyer, really underscores this. The burden or the threshold has changed. The current threshold is you have to show that there likely was a miscarriage of justice. In the new world, it's that there may be a miscarriage of justice, which lowers that threshold and adds a second part, which is that having another look at the case might be in the public interest, which is very discretionary. So again, I think that the federal government and Minister Lametti have done an amazing job, and I think that I wish we had this regime in 1986, or I wish that David Milgaard had never been convicted.
Yeah. Just as a final thought, and just so people understand how steep the hill is, in the Milgaard case, they caught the murderer. They put his DNA in the body of the victim, and yet today you and I could pick up the phone and reach people who are still working within Saskatchewan Justice that think he's guilty. So that if people want to know how steep the hill is, that's how steep the hill is. David, really appreciate you joining us on this topic, and I know you've done as much as anybody to keep the fires burning on this, working closely with the Milgaards, and I'm sure you'll join me in saying that the saddest point of all is that neither Joyce nor David were around to see Minister Lametti's legislation come forward, but we know they would be very happy about what's happening.
Well, I reflected on this. David and I were supposed to get honorary Doctor of Law degrees last year at convocation at University of Manitoba, and I accepted his posthumously. And I reflected on this, and not all stories have happy endings, and people die, people pass away, some early, some live long, rich lives. And the question isn't whether you lived, but whether you lived with meaning. And I take great comfort. And I know that in the spirit world, both David and Joyce know that whatever travails happen in their lives with the announcement of the new legislation, their lives had meaning. And that's the most important thing.
Miigwech for your time, and really appreciate talking about something that, it was 31 years ago, and it feels so close. And so thanks for bringing that attention to David and to Joyce. So miigwech. So that's another episode of Niigaan and the Lone Ranger, and your return episode.
Yep, I'm back, and I'm not going anywhere. As a matter of fact, I've set up a sleeping bag on the floor here in the studio. I'm gonna hold down my place. So yeah, I'm
not sure how Adam would feel about that.
Yeah, no. So long as you don't touch my sleeping bag, then that's okay.
Yeah, Adam never leaves either. Speaking of our wonderful producer Adam here at the CJNU studio, big miigwech and thanks to everybody here for your hard work, and also big thanks to all of our colleagues at the Winnipeg Free Press for the hard work that they do, particularly Wendy Sawatsky, who uploads and makes us sound so great and look so great on the website, and editor Paul Samin at the Free Press for all of his support. And a huge thanks to, of course, all of our listeners. I don't think we say enough thanks to all of you for supporting us on this journey. We've really been impressed and surprised at times, but I think very happily surprised at the amount of feedback that we get on the podcast.
A goodly number appear to be listening. So yeah.
Send us tweets. You can catch us on Twitter. Big miigwech for joining us, and we'll see you down the trail.
Adios.